Hi everyone and welcome back to another video. I'm going to be talking in this video about Lucy Connolly, the wife of former Conservative Councillor Ray Connolly, who lost her appeal against her sentence of 31 months in prison following her guilty plea to the offence of publishing material intending to stir up racial hatred. In this video, I'm going to go through the judgment of the Court of Appeal and explain how they came to their decision to reject her appeal. Now, I know this case invokes strong opinions on both sides of the argument. The purpose of this video is not to express my own view, it's simply to outline how the Court of Appeal came to their decision to reject her appeal. Feel free, and I know you will do, to add your own comments down below and let me know what you think about this case. Welcome to my channel, Andy on Crime, where I talk about high-profile criminal cases and other aspects of criminal law in England and Wales. And if you would like to support my channel, you can become a member by clicking on the button down below and you can get exclusive perks, or you can click the link in the description down below and sign up with NordVPN, where you can get a huge discount on a range of their plans. By doing so, you will be supporting my channel, so thank you. With all that being said, let's get into the video. So starting off with the background to this case, Lucy Connolly was convicted under section 19(1) of the Public Order Act 1986 for the offence of inciting racial hatred. The facts behind this are that on the 29th of July 2024, she posted this tweet following the tragic murder of 3 children in Southport. Now, that tweet itself was seen 310,000 times and was reposted 940 times. She was arrested and she pleaded guilty to the charge and was subsequently sentenced to 31 months in prison. And I have done a separate video on her sentencing, which I've put a link in the screen above if you do want to check that out and understand the rationale behind it, even if you disagree. Now, the offence of publishing material intending to stir up racial hatred involves either intending to stir up racial hatred or publishing material likely to do so. Now, in this case, the prosecution asserted that Lucy Connolly had the intent to incite racial hatred, citing her tweet and other social media activity at the time. Her tweet was viewed as directly encouraging violence in a sensitive social context and following widely shared but false rumours that the attacker in the Southport murders was an illegal immigrant. Lucy Connolly deleted the tweet after 3.5 hours and downplayed her involvement in WhatsApp messages which were shared at her sentencing, suggesting that she'd play the mental health card. But she did issue a public apology on X after the tweet was reported. Now, following her sentence, she appealed to the Court of Appeal and she had different legal representation. So she was represented at her initial hearing by someone called Thomas Muir, but by the time she had gone to the Court of Appeal, she had got rid of him and replaced him with someone called Adam King. At her appeal against her sentence, she was not challenging the conviction. She wasn't saying, I'm not guilty of the offence that I've pleaded guilty to, but I disagree with the sentence. Now, when someone appeals to the Court of Appeal, the test that the Court of Appeal judges will be applying is whether or not the sentence is manifestly excessive. So sentencing itself is an art, not a science, and 2 judges could look at the same fact pattern and come to different sentences, one perhaps at the lower end and one at the upper end. It's only if the sentence that was awarded in this case was beyond excessive, so manifestly excessive, that the Court of Appeal will interfere and reduce that sentence. Now, the grounds put forward by Lucy Connolly were twofold. Firstly, she disagreed with the fact that her lawyer, Mr. Muir, at the sentencing hearing accepted that this was a Category 1A offence, i.e. this placed the offending in the most serious category for this type of offending. And then the second ground was that the mitigating factors in this case, i.e. things that would lower the sentence, were not taken properly into account by the judge at the sentencing hearing, meaning that when she was sentenced, it was not reduced significantly to reflect the fact that she had pretty good mitigating factors in her view. So those are the 2 grounds that she was appealing on. Now, the judgment itself, and I've put a link in the description down below to it. I'm not going to go through it in huge amounts of detail. I'm just going to try and give you a gist of what the Court of Appeal decided. So if I start off with the first ground of appeal. Now, the Court of Appeal took the unusual step of calling both Lucy Connolly and her original lawyer, Mr. Muir, to give evidence. Now, this is not normally the case because most appeals are dealt with by the submissions that are made at the hearing itself and also the documentation that's provided in advance of the hearing. It's unusual for live evidence to be heard, but in this case it was deemed necessary. Now, the gist of Lucy Connolly's argument was that she did not understand that she was accepting that she was intending to stir up racial hatred, which was something that would place the offending in the most serious category. Now, what Lucy Connolly was concerned about at the time was pleading guilty at the earliest opportunity. She didn't want to lose any credit, so this is the amount that gets deducted from your sentence for a guilty plea. And her lawyer was advising that if she was challenging the fact that that she intended to stir up racial hatred, this might necessitate what they call a Newton hearing, which is where you plead guilty to the offence but deny some of the facts that the prosecution are alleging. And the facts that you are denying means that there would be a material difference to sentence. So just to use a really basic example to explain this, if you pleaded guilty to the offence of battery on the basis that you had punched someone and the prosecution were alleging that you punched them 6 times and you only accepted punching them 1, albeit you accept that you were guilty of the offence of battery, the difference between 1 and 6 punches would make potentially a material difference to sentence because it would put it in a higher category of culpability. So you might have a Newton hearing where you essentially have a trial where the verdict has already been decided. It's simply the facts behind the case which are determined in court, and then you'll subsequently be sentenced on the basis that the court found. So that was something that Lucy Connolly wanted to avoid, having a Newton hearing. It was something her lawyer advised her against. Now, when it came to Mr. Muir's evidence, he produced what's called an endorsement, which is effectively when you advise your client on the case that before them, and then they subsequently make the decision to plead guilty, they sign something called an endorsement, which is where the lawyer will write out effectively what's been explained to them, the advice that's been given, but the fact that they are pleading guilty of their own free will. They're not being pressured by their lawyer to do so. And this is something that Mr. Muir did and produced as part of the appeal hearing. But also in that, it went further than what I would say would be a normal endorsement, because he produced what's called a sentencing note ahead of sentencing of Lucy Connolly, which goes to the court and sets out the nature of the mitigation and what is accepted by defence when it comes to sentencing. Now, Mr. Muir stated that he had shown Lucy Connolly this sentencing note and allowed her to read it, which outlined in there that when it came to sentencing, that they were accepting that this was a Category 1A offence, placing it in the highest category. Now, Lucy Connolly's lawyer at the appeal stated that effectively her argument was that given everything that was going on, she'd never been in trouble before, she didn't really understand what was happening. So it was going to be for the Court of Appeal to determine whether or not they believed that her lawyer had advised her properly and that she fully understood, or in fact that given that she was new to these kind of proceedings, had never been through it before, that she didn't know what she was signing. So when it came to the decision of the Court of Appeal, they took the side of her lawyer, who had documented what he had explained to her, or what he purports to have explained to her, pointed out the fact that Lucy Connolly is an intelligent woman and is someone who had it explained to her on numerous occasions. So they came down on the side of her lawyer. So that first ground of appeal failed because they didn't accept her contention that she didn't know what she was pleading guilty to, or indeed accepting when it came to categorisation of the offence. So the category of the offence would remain a 1A offence, which attracted a starting point of 3 years. And that's before any aggravating or mitigating features are looked at by the court. And in relation to ground 2, which was the suggestion that the trial judge had failed to take into account mitigating factors and reduced the sentence significantly, the Court of Appeal also rejected that. If you think back to what I said at the start when I talked about appeals itself, the court will only interfere if the sentence is manifestly excessive. So although the mitigating factors were put forward as part of the sentencing process, the fact that the judge had not reduced the sentence significantly, the Court of Appeal found that there was no misdirection or error of law or misapplication of the sentencing guidelines by the trial judge. On one view, potentially he could have reduced the sentence more to reflect the mitigating factors, but the Court of Appeal will only interfere if the sentence is manifestly excessive. And even if there's a suggestion there could have been a slight reduction, that does not make the sentence that was awarded at the original hearing manifestly excessive, so the court refused to intervene. That being said, the decision was that the appeal on both grounds failed. So having failed in her appeal against her sentence, the sentence of 31 months will remain. She will serve 40% of that if she's not released earlier under some sort of scheme that I'm not au fait with, but she'll be released at the 40% point under the new guidance that was published in relation to certain offences under a certain number of years. People are now released at the 40% instead of the halfway point. In terms of a conviction, that will remain unless she subsequently challenges the conviction, and she'd have to put a separate appeal to the Court of Appeal to do so. Not quite sure on what basis she would do so, but I know that there are quite a few individuals on social media and a few organisations that are supporting her cause, so it'll be interesting to see what happens in due course. In terms of her sentence, again, she would have to produce new evidence to show that her sentence was manifestly excessive before the Court of Appeal would intervene, given that the appeal in this instance was rejected, even though she challenged the fact that she didn't understand the sentencing categorization that she was accepting, or that mitigating factors were not taken into account. It's difficult to see how that sentence would be changed. So I think at this stage it's probably unlikely that that will happen. So to summarise, Lucy Connolly appealed against her sentence on two grounds. The first ground was that the categorisation of the offence was wrong. She stated that she was not aware and would not have accepted the offence being a Category 1 on the basis that she accepted that she intended to stir up racial hatred. They called her defence lawyer who represented her, who produced evidence that he fully informed her of that. She denied that that was the case, and the Court of Appeal determined that her lawyer, providing the evidence that he did, was credible, and therefore they did not believe that she was unaware that she was accepting that she intended to stir up racial hatred. So that ground failed. And the second ground was that she felt that mitigating factors were not taken into consideration. The Court of Appeal stated that even though mitigating factors can reduce sentences, it would not have made the sentence manifestly excessive in its current form. Therefore, they would not interfere with that sentence, and therefore the appeal failed. She will remain in prison to the 40% point in her sentence unless she is released before that, and she will also be convicted of this offence unless she subsequently decides to challenge her conviction, and we'll wait and see whether or not she decides to do so. What do you think about this case? Please let me know in the comments down below. Thanks for watching. Take care.